Okay, picture this. You're right in the middle of dinner, winding down after a really long day, and suddenly, bam, there's a loud knock on the door. You open it, and it's an agent from the Ohio Public Children's Services Agency, or PCSA. Look, for any parent, that unexpected moment is literally terrifying. Total panic sets in, right? It's so easy to feel completely powerless in that exact second. But stick with me because in this explainer, we're going to demystify exactly what you need to know to protect your family. We are breaking down the specific statutes, the timelines, and those rock-solid constitutional rights that act as your legal shield in Ohio. Because you should never have to navigate this system blindly or make permanent decisions out of temporary fear.
So here's our game plan for this explainer. First, the knock on the door. Second, decoding CPS labels. Third, the investigation rulebook. Fourth, emergency removals and courts. And finally, your ultimate protection playbook. Let's get right into it. Section 1. The knock on the door, facing that initial encounter.
All right, so when a PCSA agent shows up totally unannounced, your heart is going to race. It's just human nature. And most parents, acting completely out of fear and just wanting to seem, cooperative, immediately surrender their rights. They let the investigator right inside, answer every single question, and just assume that doing whatever they're told is the quickest way to end the nightmare. But listen to me. It is absolutely vital to know your immediate legal reality. Yes, the investigator is there because someone made a report, and under Ohio law, they are legally mandated to investigate. But an investigation is just a process. It is not a verdict. And a knock on the door is definitely not an immediate mandate to just hand over your constitutional rights and put your family in legal jeopardy.
I want you to really let this quote sink in, because it grounds your entire defense directly in the U.S. Constitution. It says the investigator is a state agent, that the home is a sanctuary, and that the right to family integrity is one of the most cherished liberties in the American legal tradition. This is huge, guys. It reminds us that state power is not a blank check. Without a court order or immediate, life-threatening danger, the Fourth Amendment fully protects your home from unwarranted searches. You are literally under no legal obligation to just swing your doors open to a state agent without a warrant. I don't care how demanding or official they might sound.
Moving on to Section 2, decoding CPS labels, or what we like to call the language of the state. So, the specific labels the agency uses will dictate exactly how your case plays out. You've got to understand the fundamental difference between these two terms under Ohio law. Neglect, that one implies that you, the parent, are directly at fault, maybe due to your actions or habits. Dependency, on the other hand, removes parental fault entirely. It basically means a child lacks adequate care due to circumstances completely outside of your control, right? So if you tragically lose your job and get evicted, that might trigger a dependency label. But if the state is claiming you're ignoring your kids to go out partying every night, they're aiming for a neglect label. Knowing this distinction is a massive strategic advantage because it completely dictates your defense strategy and what the agency can actually demand of you. All right, Section 3, the investigation rulebook. Let's look at the guardrails on state power. Now, your caseworker probably isn't going to offer up this information, but Ohio law demands that they inform you of the specific allegations against you immediately upon initial contact. Do not let them go on a vague fishing expedition through your whole life. Stop them right there on the front porch and ask directly, what are the specific allegations? Hold them strictly to that scope. At the same time, keep in mind that by law, they are strictly prohibited from telling you who reported you. So please don't waste precious time and energy demanding to know who called. Focus 100% on the substance of the complaint itself. Under the Ohio Administrative Code, you actually hold a massive amount of leverage as a parent. They cannot simply pull your kid out of math class and interrogate them without your explicit consent. The only exception is if there's an immediate, life-threatening danger, what the law refers to as exigent circumstances. This protection is so crucial, you guys, because kids are highly suggestible and can easily misinterpret leading questions from some stranger with a badge. And hey, if the agency does bypass your consent based on a claimed emergency, the law dictates they must attempt to notify you that exact same day and formally document their reasoning. Time is a funny thing in these cases. It's your greatest ally and your absolute worst enemy. You need to memorize this timeline to hold the system accountable. By statute, an investigation has to initiate within 24 hours of a report. Then, the agency generally has 45 to 60 days to reach a final case disposition. They cannot just drag it out forever, hoping to find more evidence against you. And finally, if a formal complaint actually makes it to juvenile court, the absolute hard deadline for the dispositional hearing cannot exceed 90 days from the filing. Knowing these deadlines is how you stop the state from leaving your family in a state of indefinite, agonizing limbo.
Let's tackle Section 4, emergency removals and courts. The worst-case scenario.
Okay, we have to talk about the absolute most terrifying possibility: emergency removal. CPS can only bypass your Fourth Amendment rights and take a child from your home without a prior court order if they can definitively prove exigent circumstances. And let me be crystal clear, this is an incredibly high legal bar. It means there is an immediate, imminent, and life-threatening risk of physical harm, sexual abuse, or severe neglect, and there is literally no time to go to a judge and get a warrant. Disagreeing with your parenting style? Not an exigent circumstance. A messy house? Absolutely not an exigent circumstance.
If the unthinkable actually happens and your child is removed under those emergency provisions, you are not left waiting for weeks to see a judge while your family is torn apart. Ohio law triggers a lightning-fast legal process: 72 hours. That is the absolute maximum. The clock starts ticking immediately for the juvenile court to hold a probable cause or shelter care hearing. This rapid turnaround is there to ensure that the state's emergency actions are subjected to real judicial scrutiny almost instantly, giving you a very fast window to legally challenge the removal.
During these incredibly fast, high-stakes proceedings, your rights are remarkably robust. Under Ohio Revised Code Chapter 2151, you have an absolute, unequivocal right to an attorney at all stages of juvenile proceedings. If you can't afford one, you have the right to appointed counsel. Period. Plus, the state carries a heavy burden here. They must prove to the judge that they made reasonable efforts to prevent the removal. That means they have to actually prove they actively tried to offer you services, help, or resources to safely keep your family together before they resorted to the extreme step of taking your child. Finally, Section 5, your ultimate protection playbook. Let's talk about taking action. We need to map out your strategic rights because there are hard lines that CPS absolutely cannot cross without a court order. They cannot force entry into your home. They cannot force you to take a voluntary drug test. They cannot subject your child to physical or medical examinations without your consent. And they cannot legally retaliate against you simply for asserting your rights. Understanding these limits is the absolute bedrock of your defense, because when you know exactly where those boundaries are drawn, you can confidently stand your ground without the fear of state overreach. So when you hear that unexpected knock, I want you to follow these exact boundary-setting steps from the very first second. Step 1, step outside and physically close the door behind you. This is so critical because it stops investigators from claiming they saw something suspicious in plain sight inside your home, which they'll use as an excuse to force entry. Step 2, look them in the eye and ask directly, do you have a warrant or a court order? Step 3, if they don't, politely but firmly state, I do not consent to interviews or searches without my attorney present. Boom! You've just set the rules of engagement right then and there. You have some incredible legal tools at your disposal here. First off, Ohio is a one-party consent state, meaning you can legally record any conversation you're a part of. Do this every single time. Second, keep a meticulous written contact log of every interaction, phone call, and email. Third, demand to see your county's Memorandum of Understanding. That's their internal playbook detailing how CPS and the police coordinate locally. And honestly, perhaps most importantly, never ever assign a voluntary safety plan without a lawyer. These plans are basically legally binding contracts disguised as helpful suggestions, and trust me, they can easily be weaponized against you later in court.
I really need you to internalize this fundamental truth. Asserting your constitutional rights is not evidence of guilt. It is your absolute duty as a parent protecting your home. Refusing unwarranted entry, declining voluntary drug tests, demanding an attorney. These aren't acts of defiance. They are the exact guardrails the law provides to keep the system honest. When parents confidently use these tools, it forces the agencies to rely on actual evidence and court oversight rather than relying on intimidation and administrative overreach.
As we wrap up this explainer, I want you to remember this. An informed parent is a protected parent. You now know the strict rules Ohio investigators have to follow, the timelines they are bound by, and the incredibly powerful constitutional shields you possess to defend your home. So I'm going to leave you with this final thought. If the state unexpectedly knocks on your door tomorrow, will you let fear and intimidation dictate your family's fate, or will you confidently use the law to protect your sanctuary? Keep learning, stay vigilant, and never be afraid to stand up for your rights.